Hi, I'm Vittoria Logli, and I'm here with 𝐆𝐨𝐸, attorney at law, specializing in residential real estate. Today, we're going to discuss the top legal considerations when selling your home. And be sure to watch to the end of the video when Zach tells us how you can save thousands of dollars by using a legal counsel. Thanks for joining us today, Zach. So tell us, what is your role in the real estate transaction?
Sure. Well, thanks for having me. It's a pleasure to speak with all of you. So the attorney's role. The attorney's role is very important, especially here in Illinois. One of the things that I do right off the bat when I get a new contract is I review the contract. I review all the terms of the contract, and I make certain that everything's been prepared sufficiently, at least enough to get us into the attorney review period. Beyond that, I advise the clients. I provide counsel to the clients. I work with the real estate agents, I work with the title agents, I work with the opposing counsel or the other party's attorney. I negotiate attorney review and home inspection matters. I clear title, which is one of the most important things that I do, and that
So what is that? Can you kind of explain a little bit what it means to clear title?
Sure. So one of the things that I'm looking for when I run a title search is, are there any liens on the property? Are there any judgments? Are there any unreleased mortgages? Are there any unpaid tax bills? Are there bankruptcy issues, divorce issues, trust issues?
So that as a seller, you're providing a clean title to the buyer, and as a buyer, you're protected and getting a clean title that doesn't have any old liens. Is that right?
Correct, yes.
Okay.
That's actually the most important part of an entire real estate transaction, is to tender clean title as a seller and to receive clear title to the home as a buyer.
Right, good. So I do want to say that not all states require real estate attorneys. About half in this country do, and others like Delaware, Vermont, the Carolinas, Alabama require real estate attorneys. If you're in a state that does not require a real estate attorney, it's still highly recommended and suggested. If this is your biggest sale, you really need to be represented properly, and it's worth the $1,000 or whatever it is that you might need to pay to hire an attorney, right?
Absolutely, absolutely.
Yeah.
With the real estate transaction, if it's handled correctly by an experienced real estate attorney, there should be no issues. If it's handled incorrectly,
Right.
There could be enormous issues.
Right, absolutely. So another thing to keep in mind is that the attorneys get the boilerplate, if you will, contract that's standard in your specific area. As real estate agents, I cannot modify that attorney. There are blanks and I just plug and play. I fill in the blanks. I am not, as a real estate agent, legally able to play attorney or modify the contract. So oftentimes there are a lot of holes in these contracts, and this is where the attorney comes in. Zach is able to modify and put language in the contract that might otherwise not be there. Can you give an example of what that might be?
Sure, yeah, and that's very important because the contract comes to me as a standard contract, but every real estate transaction is unique to the seller and to the buyer.
Very good point.
So when I receive a contract, if I'm representing a buyer, I go through the contract and I propose a host of modifications. Things such as I try to build in an appraisal contingency, which is very important. If the property is within an association or is a condo, I request certain condo or association documents, and I review those to make sure that everything is as it should be. And a lot of additional modifications that I propose, and I do these modifications to further protect you as a buyer or to protect you as a seller.
Right. So Zach, what are the top things that a seller should know from a legal perspective when selling their home?
Yeah, so very important. Every seller knows what they've put the property on the market for and what it's going to sell for, but most sellers are not aware, at least not until the very end of the transaction, what are they actually going to walk away with?
What are you going to net?
What are you going to net?
Right.
And that's what it all comes down to. How much do you walk away with after the closing costs?
Right, right. So what plays into that?
Sure. So one of the things I discuss with sellers right off the bat, if I can, is what these closing costs are, and that is, what are the transfer taxes?
Right. Transfer taxes, by the way, aren't paid in every single case. First of all, we should explain what a transfer tax is, but also your specific municipality or town will determine whether there's a transfer tax, which could be thousands and thousands of dollars, right? Here in Glenview and in Northbrook, we do not have a transfer tax, but could you kind of explain what that is and how it works?
Sure. So there's typically 3 transfer taxes. There's a state transfer tax, which is $1 per thousand. There is a county transfer tax, which is 50 cents per thousand, and the sellers always pay both of those 2 taxes.
Okay.
However, every municipality is different. Some municipalities have transfer taxes, some do not. As Vittoria mentioned, Glenview, Northbrook do not. Highland Park, the seller pays $5 per thousand.
Right.
In Chicago has a great transfer tax.
They really get you there, buy and sell.
Yeah, in Chicago, the seller pays $3 per thousand and the buyer pays $7.50 per thousand.
Wow. Yeah.
Right,
And
so
then Highland Park, you were saying?
Highland Park charges $5 per thousand. Buffalo Grove charges $3 per thousand.
What about Winnetka and Wilmette?
Yep, they both have transfer taxes as well.
For the seller side.
For the seller side.
So some can be seller side, some can be buyer side, or they can get you on both sides like the city of Chicago does.
That's correct.
Right?
That's correct. And in addition to the transfer taxes, one of the other things that I like to make the sellers aware of right off the bat is they're going to be offering a tax credit to the buyers for tax bills that have not yet been issued, but that will come out in the future.
Right. So property taxes are paid in arrears, right? Meaning a year behind.
That's
when
correct.
You're buying a home and you're selling a home, the seller has not paid those property taxes yet. So, and they won't be due for a full year when then it's transferred to a new person. So how does that get handled?
Sure. So when you're representing a buyer, the last thing you want to do is have to go find the seller a year from now and say, hey, seller,
you owe us some cash for the taxes.
Correct. You owe us some cash or you have to pay your taxes, because those sellers may no longer be around. They may not cooperate. So the contract provides that the seller has to give the buyer a credit at closing to account for those future tax bills coming out. How are the tax credits calculated? Well, the contract provides that the tax bill, the most recent tax bill, is prorated at either 105 or 110%, although that could vary.
Sometimes 107. That's something usually the agents will negotiate in the front end, or sometimes people put in TBD for the attorneys to figure it out.
Correct. And so
how do we really know? I mean, what do we know that what Cook County's or Lake County's going to do or Will County's going to do in the future?
That's correct.
Right?
Based on
it's
the
time
right, based on the time of the year, based on where that property is within the reassessment cycle, the tax proration amounts could vary. And so it's important to understand that, understand when 105% is appropriate, when 110% is appropriate, or when something else is appropriate.
So what if they're just arguing and fighting and fighting and fighting, and we cannot get to an agreement on a percent? Then what can happen that, putting things in escrow? Like, how would that work?
Yeah, so if the parties cannot reach an agreement on what that tax proration percentage should be, we could propose a tax reproration agreement where we set aside a certain amount of money in escrow until those tax bills come out in the future. And after they do, we recalculate what the credit should have been.
Yeah, that's not as typical. People don't like to have their money held for 9 months or a year until that happens. But sometimes, what percent would you say happens in that way?
I think nobody likes to do a tax reproration
very rare,
agreement.
Like 1%.
Right. It's pretty unusual, but sometimes it's necessary.
Right. So in the real estate contract, there are specific contingencies that need to be met after it goes under contract, right? So getting under contract is only really half of the battle. You're only halfway there before you actually get to the closing table. So what are some of those contingencies that sellers need to be aware of, and buyers as well?
Yeah, sure. So when the parties reach an agreement and there's a contract, that's more or less when the race begins, but we're nowhere near the finish line.
Right.
First thing that we do is we get through attorney review, and this is where both attorneys propose modifications
to the
contract. The contracts provide that there's 5 business days from the date of acceptance for attorney review to occur. The next contingency...
How often does it actually get done in that 5 days? It's not very
Never.
often. It's usually like 10 plus days.
It's right. The 5 business days is the timeline by which the buyer's attorney has to send out his or her letter with the proposed modifications.
Right, not for it to actually be completed.
Right, as long as both parties are operating in good faith and working towards resolution, it could go 7 days, 10 days, or longer, but we do our best to try to get that wrapped up as soon as possible.
Great.
The next contingency is, of course, the home inspection contingency. And that involves the buyer doing a home inspection, and the buyer's attorney is going to send a letter to the seller's attorney with some requests for repairs, or sometimes with a request for a credit in lieu of repairs.
Right, and so this is where it's super important for your agent to have a great relationship with the attorney that they're working with, because agents will help negotiate the inspection issues alongside of the attorney. It's very, very important.
Super important that the real estate attorney and the real estate agent have a really good, close working relationship, because we help each other out, we rely on each other, and when there's a solid team, things get done, and they get done quickly, and they get done correctly.
100%. Zach is part of my team, and he's my secret weapon, as I like to say, because he will get the job done. You know, it's super important to have a great working relationship.
All right, so the next contingency that's relevant and often worrisome is the buyers are going to have an appraisal contingency. Most likely, they'll have an appraisal contingency.
So wait, let's step back a second and explain kind of what that is, because a lot
Sure.
of people don't understand what that actually is.
Right. So if you're selling your home for $500,000, or if the buyers are buying a home for $500,000.
So the contract says it's $500,000.
Correct. And then the buyer's lender goes out and does an appraisal of the property, and lo and behold, the property doesn't appraise for $500,000.
$475, we'll say, right?
That's correct.
And the way the appraisal is done, which is super important to understand, is the same way that sort of agents come about with that price. They pull 1 year's worth of data within 1 square mile. Sometimes they can do 2 or 1 circular mile. So the way that the appraisals work is that the buyer's lender randomly picks an appraiser out of a database, and they come to the house and take a look at the house, and they pull comps, closed properties within 1 year and 1 square mile. And then they compare the property at hand to all of those other properties. They do take into consideration any updates, upgrades, improvements that have been made to the property, but they're really looking for apples to apples, meaning 4 bedrooms, 2 bathrooms, 2-car garage, around the same square footage, interior and for the land, and things like that, right? So that's how an appraisal works. And what happens when it doesn't appraise out?
Sometimes they don't.
Especially in these days where we have a lot of values have gone up so quickly.
Correct. So what happens when I'm representing a buyer and a property does not appraise out at the value that's indicated in the contract? I'll reach out to the seller's attorney, and we will negotiate a value that the property can be sold for. If both parties can agree on that value, then the transaction moves forward. If the parties cannot agree on a new sales price, then under an appraisal contingency, the buyer has the right to terminate the contract and receive all their earnest money back.
Right. So I think that's really important to think about, and especially from a seller perspective, if the property does not appraise out one time, it's likely it won't appraise out again. So super important to keep in mind that from a seller perspective, if your property does not appraise out now, a new buyer in the future, in the next month, couple of weeks, will also have the same problem with it appraising out. Unless there's some weird glaring error, which I've had some lenders make and some appraisers make, but it's not as typical, it will be challenging to get it to appraise out, right?
Correct.
So that's something that all sellers need to keep in mind. So that's a very important contingency, is the appraisal contingency.
So now we're about 3/4 of the way through the transaction.
I'm tired. I don't know about you, but this is making me tired. Okay.
If you make it through attorney review, if you make it through home inspection, if your property appraises out at the contract sales price, the buyer is still going to have a financing contingency. That's, in all likelihood, that's the final contingency. And that is satisfied when the buyer's lender says, congratulations, you've received a clear to close on the loan.
And when does that usually happen? How far in advance of the closing do we get a cleared close? Because I know this is a sticking point oftentimes.
This is a very frustrating thing for sellers,
Yes.
because sellers want certainty. The buyer's going to be able to close. They want that as early as possible. Unfortunately, lending practices involve not issuing a clear to close oftentimes until 3, 4, 5 days prior to closing.
Or the day before closing sometimes. Oftentimes you won't get a clear to close until the day before closing if there are certain conditions that the buyer has to meet. And that's what's super important for an attorney to keep on top of. Like, okay, if we have to extend the contingency period, what are those conditions that the buyer has to pass in order to get that clear to close?
Correct. One of the things that I do as an attorney when I'm representing a seller is I reach out often to the buyer's lender and say, what's the status of the buyer's loan? Are they clear to close? If not, when do you expect them to be clear to close? And if I'm representing a buyer on a transaction, I'm in constant contact with the buyer's lender, asking the same questions. And I monitor the status of the loan so that we could know as early as possible and with as much certainty as possible that the transaction is going to close on time.
Again, I just want to preface this by saying not all attorneys do this. Not all attorneys will stay on top of the lender and be in close contact with that lender. Not all real estate agents will actually pick up the phone and call the lender prior to accepting or having their seller accept that contract. Super important to have a team that is integrated and is going to have all the bases covered. So once we've met all of the contingencies, including getting the clear to close from the buyer's side, what happens on the day of closing?
Sure. So now it's time to close. Typically, if I'm representing a seller, I will have already met with the sellers, usually at their home, 2-3 days prior to closing to have them pre-sign closing documents.
So the seller here in Illinois and in our area, when represented by an attorney, you don't have to go to closing, which is huge because you're packing up your life and you're maybe on a truck somewhere out of state, or you're packing up your life on a truck and you're maybe leaving the state or moving across the state. So you don't have time to sit here and sign documents on the day of closing. So you're able to pre-sign all of these documents.
That's correct.
You're a really good attorney, because not all attorneys do that. Some of the attorneys make their clients come to closing, which is ridiculous.
Yeah.
Anyway.
Yeah, so no, that's very important. You obviously have much better and more important things to worry about than to be at the closing. At the closing, if you choose to show up, you're more than welcome, but you're likely going to sit there for an hour, hour and a half watching the buyers sign their loan documents.
Right. And then waiting for the actual funds to clear.
That's correct. Yes. So if I'm representing a seller and it's the day of closing, we will be in contact. I will be calling you throughout the closing, letting you know how things are going while you're, moving on to the next property or doing whatever you're doing. And the closings take about an hour to an hour and a half. And
maybe longer, depending on how quickly that wire comes in from the buyer's lender.
That's correct.
Right? So at what point is it actually, everyone signed their life away, at what point is it actually done?
Sure. So when we're at the closing, the buyers are signing all of their loan documents. All of those loan documents get sent to the buyer's lender. The buyer's lender is looking to make sure that everything was signed properly, the way it should be. And once the lender is satisfied that all the documents have been prepared and signed correctly, the buyer's lender will issue what's called funding authorization. That is what is necessary for the title company to cut checks and for the buyers to get keys. Once we have that funding authorization, the deal is closed.
So that means the money has been transferred from the buyer's bank into the title company, and then how does the seller get their funds?
Sure. So after the closing is funded, the seller has different options as to how they could receive their funds.
Okay.
We could wire the proceeds directly to the seller's account. That's one option. Sometimes that's necessary. Most of the time it's not.
Okay.
Or we could have a check cut to the sellers.
An actual check.
An actual check. And typically that's the way that it's done. And for my clients, I will meet them after the closing and hand them the check. I feel that's the safest way to do it.
Right.
And it's a great opportunity for me to, again, congratulate the sellers on a successful transaction.
That's amazing. Let's kind of take a second and discuss wiring fraud, because this is rampant right now, and that's why Zach likes to get the physical check, right? So what do we need to be aware of with wiring fraud from a legal perspective in a real estate transaction?
Sure. So the bad guys have kind of figured out that there's a lot of money going back and forth in real estate transactions, and you can never be too careful. You'll notice in virtually every email that you receive, whether it be from a title company, an attorney, a lender, there's always going to be a warning about being
Even
cautious.
agents, even we have those warnings now.
Correct. There's going to be a warning. Be careful about wiring money. So when you're a buyer and you're buying a property, you're likely going to have to wire money into the title company in order to make the purchase. And usually that wire will be sent either the day before or the morning of. And I always advise my clients when I help them get wiring instructions, you're going to receive a set of secure wiring instructions from the title company. Once you receive that, I will ask you, call the title company back and verbally verify the account number and the routing number. And only after you've done that.
Verbally verify. Call them, get on the phone and call someone, speak to a human being to verify the numbers.
Correct. And only then do you go ahead and wire the money. Now, when you are a seller, if you want the money to be wired to you, again, that's an option that's available to you. And right after the closing, the proceeds from the sale will be wired into whatever account you specify, and the money will arrive within a couple hours after the closing.
Right. So very important to be aware of wiring fraud, and especially in real estate. So now the part you've been waiting for. How can you save thousands of dollars by hiring an amazing real estate attorney in the sale of your home?
Sure. So there are things that we could do to save you money. First, after the contract is signed and we begin to work on it, one of the things I do is I look at the tax proration percentage. Is it an appropriate percentage, or is the buyer suggesting something that's not reasonable? Oftentimes, as we mentioned,
right,
proration percentage should be between 105 and 110%, but oftentimes I'll have a buyer's attorney request 125, 135%, and that is probably not legitimate. Another thing that we could do to save you money is we could ask you as a seller, do you have your survey?
Your plat of survey.
Your plat of survey from when you purchased the property. Correct.
So what is a plat of survey?
A plat of survey is an overhead view showing the lines of the survey, showing where the house...
lines of the property, exactly where the property is and where the property borders are.
Correct. There's usually three relevant lines. There's a property line, there's a building setback line, and sometimes there's easement lines. But a survey shows us a picture of all of that, and we're looking to see, is the house situated within the lines and not encroaching over any lines, and are there any property of neighbors that are encroaching over lines, or is that property where it should be? So a survey is giving us a bird's eye view of the house, of the property, of the lines.
And in a real estate transaction, a seller needs to provide to the buyer by closing a current and accurate survey. So if there haven't been any improvements made, if there has been no changes, oftentimes Zach will ask the other party to take maybe an older survey, as opposed to having the seller pay $600, $700, $800, $900 to get a brand new survey. Is that right?
That's correct. The contract requires that the seller provide a survey dated not more than 6 months from the date of our closing. Again, as Vittoria mentioned, if you haven't made any new improvements, structural improvements to the property that would change the footprint of the property on the survey, then we could ask the buyer's attorney and the title company, will you accept the older survey? To do so, we would have to have you sign an affidavit that there's been no new improvements, and we'd have to get permission from the title company. But if we could achieve that, yes, you'll save about $500, $600, $700.
Right.
The next way of potentially saving you money as a seller is negotiation, effective negotiation of the home inspection issues. Very often, the buyers are asking for enormous credits, and that may be warranted.
Or crazy repairs.
Or crazy repairs, and those may be warranted, they may be unwarranted. And so as an attorney, that's one of the most important things that I do, is that I will negotiate with the other attorney to make sure that any credit offered by a seller is a reasonable credit that is proportional to what the inspection issues actually are.
Right. And oftentimes the real estate agent, I worked hand in hand with Zach on negotiating those inspection issues, right? So I will be working with the other agent, the other party's agent, to come to an agreement as well. And then he's working at it from a legal perspective to try and save potentially our sellers lots of money in irrelevant or unnecessary repairs. What does that contract actually call for?
And this is something most people don't realize, is that the home inspection provision within a contract does not allow a buyer to ask for everything and anything under the sun, right? The buyers are going to wind up at Home Depot with the rest of us from time to time.
Right, no house is perfect.
There's no such thing as a perfect house.
Not even a brand new house, there's no such thing.
So the contract provides that in order for something to be deemed a home inspection issue, it has to be a major component of the home that's not operating for the purpose for which it's intended.
Or if it's a safety or health concern.
Correct. A home inspection issue is not supposed to be a minor repair or a routine maintenance item either. And then one of the biggest things that turns up in these home inspections is something is old. It's
like a furnace that's 15 years old.
Correct. That's almost on every home inspection report, that there's an appliance that's nearing the end of its useful life or is even beyond the end of its useful life. However, the contract says if that item is operating for the purpose for which it is intended, it doesn't matter if it's nearing the end of its useful life or beyond the end of its useful life.
Right, so if a furnace is 15 years old or 20 years old, but it's still heating up the house, technically a buyer cannot ask for that to be replaced.
Correct, and they often do, and then we negotiate from there,
right,
and we try to reach a resolution that both parties could live with.
Right, absolutely. So Zach, you must see a lot of crazy stuff going on during the attorney review period. Tell us a story, a juicy story of one of the craziest things you've seen in the last few months.
Okay, so yes, especially home inspection issues, involving home inspection issues. I don't know how juicy this is, but
I think it's juicy.
I've been doing this for over 25 years now. I've closed several thousand transactions, and I had one of the more unreasonable requests lately. I had a client who is selling her home for $450,000. Nice home, average home. The contract was entered into on an as-is basis.
So can you explain what an as-is clause in a contract?
Sure. So when a buyer purchases a home on an as-is basis, they are purchasing the home with the condition of the home reflected in the purchase price. They are allowed to do a home inspection.
You are allowed to do a home inspection. That's really important to note.
Right. They do a home inspection. They're allowed to do a home inspection. And when the home inspection is over, they are allowed to either approve the condition of the property and move forward with the transaction, or they have the option of disapproving the condition of the property and terminating the transaction.
Right. So it's pretty black or white.
It's pretty black or white.
Approve it or you walk away, right?
Correct. However, that's not always the case. Sometimes, many times, a purchaser will buy a property on an as-is basis, and they'll get the home inspection results, and lo and behold, now they start asking for repairs or worse, money. So that's what an as-is transaction is supposed to be. So now back to my client selling her home for $450,000. Buyer entered into the contract on an as-is basis. After about a week or so, the buyer completes the home inspection, and I receive a letter from the buyer's attorney asking for a credit in the amount of $45,000.
$45,000?
Correct.
So 10% of the asking price?
That's correct. And this is the
interesting... On an as-is?
This is the interesting part. The inspection issues that arose during the inspection all could have been resolved for maybe $500 to $1,000.
Wow. So how'd that end up?
So I got on the phone with the buyer's attorney. We had a very nice conversation.
You set him straight.
Things were set straight, and the transaction is back on track.
Good. Heading
towards closing in the manner in which it always should have been.
And what kind? Are they giving any kind of credit?
We're making some very, very small accommodations.
Okay, that's
Correct.
Much more reasonable, but that's crazy. And as this transaction, and they asked for $45,000. That is absolutely nuts.
That was the most extreme ask that I've seen in 25 years.
Wow.
And I would encourage sellers, if you have a buyer who is not acting in good faith, to cut them loose. Either cut them loose or be aggressive in your negotiations because it's important. One of the basic tenets in contract law is both parties are supposed to operate in good faith.
Absolutely, and that's a great thing to remember. Hope you enjoyed this video and found it informative. Super important to have experienced legal counsel when selling a home. You don't want a personal injury attorney, you don't want a divorce attorney, you want a real estate attorney like Zach. Thanks for joining me today, Zach. And if you happen to have any questions that we haven't answered, feel free to put them in the comments and we'll definitely try and address them. And thanks for watching.
Thank you.